day, my name is Arhana Ramdhew and I am a Labour Legal Advisor at Durban SEESA offices.
Good day, my name is Trishan Bisnath and I am also a Labour Legal Advisor at the SEESA Durban offices.
Today, Trishan and I are going to be discussing the importance of implementing employment contracts in the workplace and the requirements for drafting such employment contracts.
Arhana, this is a very interesting topic as we encounter queries on a daily basis in respect of contracts of employment, and I cannot emphasize the importance of it. Arhana, can you please tell us what is a contract of employment?
Certainly, Trishan. A contract of employment is a vital agreement entered between two or more parties, usually the employer and the employee. It regulates the terms and working conditions between the employer and employee and further stipulates the rights and duties between the parties.
Must the contract of employment be in writing, Arhana?
No, there are no formalities required for the formation of a contract. However, Section 29 of the Basic Conditions of Employment Act requires certain written particulars of employment that every employer is obliged to provide to an employee. It is highly recommended that in addition to these requirements, as per Section 29 of the Basic Conditions of Employment Act, the employer reduces the company rules, policies, and procedures to writing in order to create certainty, clarify responsibilities, and further regulate behavior of employees in the workplace.
Arhana, I completely agree with you, but keeping in mind, there are few requirements that must be complied with for a valid contract of employment. Namely, the parties must have reached consensus, the parties must have had the legal capacity to enter into a contract of employment, performance must be possible as well as permitted in terms of the law. All formalities must be observed in terms of a contract of employment. In a nutshell, the parties may not agree to anything less than is prescribed by legislation.
Yes, Trishan, I'm sure that the employer would not like to begin an employment relationship on the wrong footing. With that in mind, employees may be reluctant to sign an employment contract should they be provided an employment contract after commencing employment. Can you tell us, Trishan, does signing a contract at a later date affect the employee's appointment date?
Arhana, no, the signing of the contract of employment will not affect the commencement date. However, it's advisable to insert a clause in the contract of employment which will stipulate the commencement date or the date of appointment of the employee. This will be quite important at a later stage if the employer wants to proceed with retrenchment procedure as per Section 189 of the Labour Relations Act, where the employee will be due severance pay, and it will also be dependent on the number of years that the employee has been employed at the workplace by the employer.
That's good to know, and I'm sure that this will assist parties in resolving any uncertainties amicably. Are there any other documents that should form part of an employment contract?
Yes, Arhana, basically any other important documentation that needs to be part of the contract will need to be attached to the contract of employment, and it also will need to be reasonably accessible for the employees at the workplace. A few examples are the disciplinary code, the grievance forms, the application for leave forms, as well as the company policies and procedures in the workplace.
I fully agree with this, as the inclusion of the disciplinary code of conduct, policies, and procedures in an employment contract is an ideal way to regulate compliance in the workplace. Failure to include such documentation and information in the employment contract would make regulating compliance in the workplace extremely difficult, as the employees can state that they have never been informed of such a rule, resulting in a conclusion that the rule does not exist in the workplace. As a result of this, taking disciplinary action would become a tedious exercise, which could have been avoided. Trishan, can you tell us what are the most commonly used contracts of employment in the workplace?
Sure, Arhana. The two most commonly used contracts of employment at the workplace are the permanent contracts of employment as well as the fixed-term contracts of employment. The permanent contract is an employment contract which has an indefinite period and can be terminated if the employee dies, the employee has reached the agreed or the normal age of retirement, or there's a mutual agreement amongst the parties concerned. The fixed-term contract is a specific contract for a specific task or a project and is only valid for a period of 3 months. It can be extended if there's a justifiable reason that exists at the workplace. An example of this is if the employee goes on maternity leave. The employer may then decide as to which contract of employment will be used in the workplace.
Will either party need to provide notice upon termination of contract?
Yes, Arhana. In terms of if the employer's business falls within the scope of a bargaining council, the notice period may differ. But however, in terms of the basic conditions of Employment Act, either party may give each other notice. And the notice periods are as follows. If the employee is employed for 0 to 6 months of employment, it's a week's notice. 6 to 12 months of employment, it's 2 weeks' notice. And over 12 months of employment, it's 4 weeks' notice. Now, the notice periods are not applicable if the employee has committed gross misconduct, like if the employee has been summarily dismissed at the workplace. And remember, if either party does not give the required notice, the aggrieved party may proceed via civil action. Arhana, I'm sure you want to give our loyal SEESA clients some good news now.
Yes, Trishan. We at SEESA have highly trained legal advisors to assist employers in all labor matters, including the drafting of employment contracts. Additional documentation and policies can also be easily accessible on our profile system. Unfortunately, Trishan, that is all we have time for today. So for any further queries, clients and prospective clients can feel free to contact your nearest SEESA branch or visit our website.